So now we will talk about the doctrine of insurable interest. So your assignment has been based on this particular doctrine of insurable interest. Now, what is the doctrine of insurable interest? Now, the doctrine of insurable interest means that um, where there is an interest that a person has in something, say a particular property or another individual or a group of individuals, which means that a person would suffer a loss should that property or individual or group of individuals be harmed. So, what is an example of insurable interest? See, the simplest example is you are a policy holder and you're purchasing a property. Okay, you're purchasing, say, a house for your stay. And then what happens? That means when you take a house insurance, the insurance company would say, yes, this property belongs to you, and so you have an insurable interest in this particular property. By and large, there are three elements of insurable interest, or in the doctrine of insurable interest, or you could also say that there are three elements that revolve around the doctrine of insurable interest. One is like liability risk, two is personal risk, and third is property risk. Now, property risk is just any risk that would cause a partial or a total loss of property. Personal risk, say, is any risk that could probably impact the health and the safety of a person or employees, right? So now let's see what the slide says. So insurable interest therefore means the interest or the nexus between the policy holder and the thing or the property or the person who is insured. So what is insurable interest? This is an essential element or it is a sine non in the contract of insurance to be considered valid apart from other general elements is the element of insurable interest. The fundamental principle that revolves around insurance contract is the principle of insurable interest. This interest specifically is pertaining to a subject matter of insurance. It implies that a specific person, body, or corporate must have some interest in the subject matter of insurance. For example, the car owner who invests in an auto insurance is said to have a direct insurable interest in the vehicle. Therefore, to have an insurable interest in something would mean that the person seeking the insurance policy would suffer loss if that insured person or property were to be harmed or lost or damaged. Furthermore, that the person would receive some financial benefit from the insured person or property's continued existence. Therefore, insurable interest must be capable of being enforced. Now, concluding on insurable interest in an application of insurance or claim helps in prevention of random issue of insurance and to prevention of speculation of risks involved. That means the insurance company normally studies the nexus or the relationship between the person who is purchasing the insurance policy and the object to be insured. So once they understand the nexus or the connection, then they're willing to issue an insurance policy. So insurable interest is an important factor that is taken into consideration by insurance policy while issuing insurance policy. Apart from that, it also helps in prevention of speculation of risks involved. The Collins Dictionary of Law has defined insurable interest as a person has such an interest in property or in the life of a person if damage or destruction of the property or death of a person would expose him to a pecuniary loss or liability. Pecuniary means financial loss or liability. So therefore, insurable interest is an integral part of insurance contract. Now, insurance is inferred bearing in mind the ascertainment of risk to the individual seeking the insurance policy and the subject matter of the insurance policy. Now, this is evaluated during the underwriting process to ensure this direct nexus. What would be examined is the person who would be exposed to a loss or financial loss in case of some harm that may be caused to the subject matter of insurance. Now, insurable interest could also be deciphered upon examining the relationship or connection or nexus between the insured and the event, as well as the subject matter involved, and then assuming the occurrence of the event to calculatively ascertain the substantial loss or injury to the insured. Now, an owner of goods will prima facie or on the face of it or directly have an insurable interest in the goods property insured. However, the property and or the ownership may change with the passage of time during the subsistence of the insurance contract. Like sometimes the property or the ownership may change with the passage of time, even while the insurance contract is existing. Okay, so we were talking about insurable interest. So sometimes an owner of goods, just reiterating a little bit, coming back to it, an owner of goods will prima facie have an insurable interest in the goods or property insured. However, the property and or the owner may change with the passage of time during the subsistence of the insurance contract. Now, in such an event, it gets relatively cumbersome or tiresome to pinpoint who the owner of the goods is at the time of loss or claim. Now, here, a great deal hinges upon any subsequent contract terms pertaining to sale or even devolution of property. Sometimes what happens, property belongs to Mr. A and he purchases an insurance policy, say a house insurance policy or a fire insurance policy for the house. And then what happens? He plans to sell it to Mr. B. So the transition takes place and the property is now Mr. B's. And Mr. B is still yet to take an insurance policy, and so Mr. A's insurance policy expires. Then what happens? So here there is a transition. And say now the policy is still existing. Say the policy is still existing, and this guy takes over the policy. Now here there's a transition again, and so now the question is who has the insurable interest. So that's why we have said that property ownership may change with the passage of time during the existence of the insurance contract. Now, in such a case, it gets relatively tiring or cumbersome, or it becomes a gigantic or a Herculean task to pinpoint who the owner of the goods or the property is at the time of loss. Insurable interest is thus at the heart of the insurance policies connecting the insured and the owner of the policy. Insurable interest can be an object or a person which, if damaged or destroyed, expires, would result in a financial hardship for the one contracting the policy or the policy holder. Now, in Lucina versus Crawford, Justice Lawrence observed in the case that a man is interested in a thing to whom advantage may arise or prejudice happen from circumstances which may attend it, and whom it imports that its condition as to safety or other quality should continue. Interest does not necessarily imply a right to the whole or part of the thing, nor necessarily and exclusively that which may be the subject of privation, but the having of some relationship or concerning the subject of insurance, which relation or concern by the happening of perils insured against may be so affected as to produce a damage, detriment, or prejudice to the person insuring. And when a man is so circumstanced with respect to matters exposed to certain risks or dangers as to have a moral certainty of advantage or benefit, but for those risks or dangers he may be said to be interested in the safety of a thing. To be interested in the preservation of a thing is to be so circumstanced with respect to it as to have benefit from its existence, prejudice from its destruction, the property of a thing, and the interest divisible from it may be very different. Of the first, the price is generally the measure, but by interest in a thing, every benefit and advantage arising out of or depending on such a thing may be considered as being comprehended. Next is this is a very interesting case if you hear me carefully. The previous case was something that the judge observed. That is what his opinion was in the case. Now, in this case, the facts of the case is there is a Minster Insurance Company and EC Parker and Company Limited, Muneka, Lloyd's Rep. Here, an insurance policy was taken for a motor yacht, Muneka, which actually belonged to one guy whose name was Mr. Sharp. But for the purpose of tax, a company called Rower Investments in Gibraltar was registered as owner of Muneka. Mr. Sharp was then given the power of attorney by the registered company to sail and manage the vessel, and he was also named as the assured in the contract of insurance. Now, during the policy, while the single crewman employed on board Muneka was away, this yacht was away. So the yacht caught fire at her moorings and became a constructive total loss. When the assured Mr. Sharp sought to recover and claim the policy, the insurers MIC declined the payment on the grounds, inter alia, that Mr. Sharp did not possess any insurable interest in Muneka. So the court decided and said that Mr. Sharp did in fact have an insurable interest in the yacht. So this is an important case law that you must mention in your answers as well as in your assignments. Next is, for an insurable interest to exist, it is not always the ownership that matters, but what matters is the actual link or the relationship between the insured and the risk insured against. In Berto Camilleri versus Harold Bartley, the court held that for insurable interest to exist, it is not absolute ownership which is required, but the existence of a relationship between the person insured and the thing which could be adversely affected by the happening of the risk insured against. Now, what about insurable interest in a life insurance policy? Now, in a life insurance policy, the factor of insurable interest will be determined at the time of purchase of the policy. Here, the one who seeks the policy or contracts the policy must have an insurable interest in the life of the insured. In case the person contracting the policy is not the beneficiary, then the beneficiary named in the contract will have to express the nexus between the purchaser of the policy and the beneficiary to evidence insurable interest to prove that upon the demise of the insured, that is, upon the death of the insured, the surviving person named in would be exposed to a loss. So therefore, in case of life insurance policy, the following persons would be considered to have an insurable interest. Listen carefully. 1, the one who purchases the insurance for one's own life, and 2, the direct dependents by blood or marriage. Blood would be who? The parents. Dependents or marriage would be spouse, children, grandchildren, or sometimes even adopted children by law. So insurable interest does not exist in case of step parents, uncles, aunties, cousins, neighbors, etc. So on continued existence. In Bartholomew Wood Turners Limited versus Middlesea Insurance, the court observed that an insurable interest exists when the insured may be said to benefit by the continued existence of the property or life insured and will suffer a loss by reason of its damage or destruction. In case of keyman life insurance or business life insurance, the person who is insured who may be regarded as a key person in business, and in case of sudden demise of such an individual, the business may be exposed to a risk or a loss. Therefore, a business may be an insurable interest in its suit officers. Now, creditors, companies, banks, loaning institutions may secure the debtors with a life insurance policy with the absolute consent from such debtors, and the policy sought will be equal to the amount owed. What is the nature of insurable interest? So insurable interest must be capable of being legally enforced. It must be lawful, not illegal. Insurable interest must not be opposed to public policy. It must be capable of calculating it in pecuniary or financial terms. Sentimental factors or love and affection cannot be construed as insurable interest. The relationship between the insured, the subject matter, and the policyholder is examined and not mere ownership. So the factor of insurable interest varies with the type of insurance. Insurable interest may be present at the time of taking the policy, but may frizzle out subsequently as in life insurance policy. Therefore, contractual provision to that extent must be secured as to the existence at the time of securing the policy and to be interpreted as that it may or may not exist at the time of claim. Example, when a husband may secure a life insurance policy for his wife and then some years he divorces and then she dies. So the husband will be able to claim. Now, there is an interesting case in this area, that is Griffith versus Fleming. Griffith versus Fleming. Griffith and his wife each signed a proposal form for a joint life policy on their lives for £500 and both contributed towards a premium. So after the policy was taken, the wife committed suicide. That is, his wife, Griffith's wife, she committed suicide, and the husband claimed the sum assured. The insurer, that is the insurance company, alleged that at the time of taking the policy, the husband had no insurable interest in his wife's life as required by the Life Assurance Act. The court, that is through Justice Vaughan William, said that or held that the husband has an interest in his wife's life, which ought to be presumed, and that it is unnecessary to go into the evidence to show any financial or pecuniary interest of the husband. Next is in property insurance, marine insurance, insurable interest must exist at all times till the time of actual possession. So this is all about insurable interest. Normally, contractual insurable interest, it refers to an insurable interest that is required in the insurance contract in order to give effect to the policy. Apart from that, we have a statutory insurable interest, which refers to an insurable interest that is prescribed by specific laws that deals with insurance. So thereby, insurable interest is basically the nexus between the person who is procuring or purchasing the insurance policy and the thing or the object or the person to be insured, right? So a question that might come into your mind is, while deciding about insurable interest, when do they decide about insurable interest? As we said in the very beginning of this class, I said that insurable interest normally should exist at the time of taking of the policy, and that's how the insurance companies give out these policies depending upon whether insurable interest exists or not. So that is also one of the primary factors that are taken into consideration while allowing or while granting insurance policies. So therefore, you could say that insurable interest should exist both at the time the insurance is purchased as well as at the time the loss occurs. Listen carefully. Insurable interest must exist both at the time of taking the insurance policy, that is when the insurance is purchased, and also at the time the loss occurs. But however, life insurance is slightly different, where insurable interest only needs to exist at the time the policy is purchased. Okay? Is there any question that you have now? So I presume not. So this is all for insurable interest. Insurable interest is an important question, examination point of view.